Judge has ordered the government to restore the Deferred Action for Childhood Arrivals program, or DACA, to its pre-September 5th, 2017 status in light of the Supreme Court's recent decision that was 5-4. That decision means that the administration must begin accepting new applications for the DACA program. Joining us now to talk more about it is KUSI contributor and immigration attorney Esther Valdes. Hi, Esther. How are you?
Hi, Logan. Very well.
So tell us more about this ruling. How did they come to that decision, and what does it mean?
Yes, this was a decision out of a district court out of Maryland, basically telling the U.S. government, asking them to now implement accepting initial DACA applications and also not to share the information with Immigration and Customs Enforcement to act on possible deportations for DACA applicants who may or may not qualify. It was a twofold decision. Practically what this means is that everybody who was not able to be qualified for the DACA program that was initiated under the Obama administration could now file not just a reapplication, but also an initial application for two things: for a work permit and also to stop a potential deportation. Since this decision came down on Friday, my office has received continuous amounts of phone calls from older siblings wanting to see if their younger siblings can now apply to stay in the United States, work lawfully in the United States, travel within the United States, and possibly even ask for what's known as advanced parole, special permission to leave the United States for educational or humanitarian purposes. So this is a huge effect on the Latino community, on the immigrant community, especially here in San Diego, where we have approximately 11,000 DACA recipients. This could have a huge potential impact, not just when the economy recovers, but to also help the economy recover.
So is this the end of it? Does this mean finally we now have a ruling on DACA, or is there something else that could be done to undo DACA?
Well, that's the big question, because I just checked the USCIS website right now, and it does not say that they are neither accepting nor processing applications. So we don't know what the Trump administration is going to do. And also recall what the Supreme Court decision actually said. They said the way DACA ended was unlawful, it was arbitrary and capricious, but they did not say that the Trump administration could not do it. So potentially we're looking at a small window of time in which any potential DACA applicant is urged to apply right now before the Trump administration either rescinds it or ends it completely.
Talk a little bit more about the information sharing, because that was another part of the ruling, this idea that if you want to apply for DACA, you have to give information. And is that information then maybe going to be used against you later to perhaps deport you?
Originally, under the Obama administration, that was almost an unspoken promise. If you give us all of your information, which is very personal information, where you live, your parents' information, how you entered, that you entered unlawfully. And of course, you're also potentially giving this to a government office. And for the first time, telling them, I am unlawfully here in the United States. That information in some states has been used by ICE officers to find someone who's no longer eligible for DACA and or has been arrested for a potentially very serious offense, including a threat to the community, to then locate the person and be able to arrest them for deportation proceedings. So what this district court decision also said, which a lot of people aren't noticing, is that it also hindered and enjoined the government from sharing this information for potential deportation proceedings.
Well, a lot to unpack there. Esther Valdes, thanks for sharing your insights and explaining it all to us. We really appreciate it. Great to see you.
Thank you, Logan.
Thanks.